Legal and ethical issues can be of particular concern to EMS providers and can provide some challenging situations to decipher and to sort through. We can divide these into a couple categories. We have legal duties as EMS providers to the patient, to our medical director, to the public. Those legal duties are set by statutes and regulations and follow general standards that have been established by society. We also have ethical duties, and these are a little more tricky to identify and to clarify because everyone views them a little bit differently perhaps. But ethical duties are those principles that identify what's normally acceptable conduct. This has to do with things like respecting your patients, having your skills mastered, knowing your information, doing your continuing education. The NAEMT, the National Association of EMTs, has a code of ethics that outlines these ethical perspective or these ethical issues and principles specific to EMS. It's pretty good. If there's going to be a civil or criminal action, it's going to be based on either actual or perceived failures in one of these areas, and those are the things we need to protect ourselves against. So, bedside manner. If you want to protect yourself from legal action, one of the keys is to just simply being nice. Now, obviously, you also need to be competent, but I like this quote that nice, incompetent doctors rarely get sued, and it's probably pretty true that most of the time when people look for a legal solution, it's because they're angry, they're upset, they don't feel like they were treated well, they don't feel like they were treated appropriately, and oftentimes that comes from unkind and what seems to be uncaring interaction with providers. By caring, by trying hard, by doing your best and making it obvious you care about people, you greatly reduce the fact or reduce the chances that someone's going to feel like they have to sue you in order to set things right. Documentation, of course, is a huge key. A couple things to think about in terms of how you document and when you document is that lawsuits or other legal actions often take years to make it into court. So by the time you're sitting on a stand answering questions for an attorney, it is likely that that call that you're being asked about, that patient interaction you're being asked about, was several years ago. The chances of you remembering the details of that incident very clearly are very small, unless you have it really well documented, and by reading your own chart, you can clearly recall exactly what happened, what was done, and why. Good documentation can actually prevent a lawsuit from occurring, because one of the first steps, if someone thinks they have grounds for a lawsuit, they go to an attorney, and an attorney is going to investigate, and they're going to do depositions, they're going to subpoena records, and they're going to pull the patient care reports, and they're going to pore over them. And if what they find is excellent documentation that thoroughly explains that you were in the right and that nothing inappropriate was done, then that's not much of an opportunity for a lawsuit. If, on the other hand, what they find in your documentation is very minimal information, a lot of holes in the story, a lot of details lacking, that's an open opportunity for them to pursue a lawsuit because they'll fill in the pieces that you left out. I'll talk real briefly about a few laws that affect EMS providers and kind of where they fall in. Scope of practice is huge, also known in some places as the Medical Practice Act. It defines, in the state of Oregon at least, it defines the maximum levels of paramedic skills, and it's set by the Oregon Medical Board. Our local protocols cannot exceed this, so this sets a ceiling for what paramedics are allowed to do. Local protocol determines what within that range you're allowed to do as an EMS provider. There's ambulance operation laws, which are a completely different section of the Oregon Revised Statutes, but you need to be aware of those. They're also set by the state. And just other things that can affect us. Other category of laws that affect us is reporting laws. And obviously we now have specific areas and specific categories of things that you must report if you become aware of them. One on this list that falls under reporting is the administrative stuff, and that's a change of address. That means when you move, you are required by law to advise the Oregon Health Authority, who issues your paramedic license or your EMT license, if you've had a change of address. And if you don't, they can cite you, they can fine you, they can even take away your license for failing to tell them that you've changed address. Another category of laws that we think about that affect us in EMS is assault and battery. And I'll talk about this a little bit here in a minute, but assault and battery could be implied either by a patient claiming that our actions and what we've done constitute assault and battery because we touched them in an unwanted way. It also happens, unfortunately, with increasing frequency that EMS providers are being assaulted by patients, by bystanders in a variety of circumstances, and that's a concern. Another category is those related to exposure and infectious diseases. This came about in the 80s mostly as a response to HIV and AIDS, that there were several protected diseases and confidentiality rules around who could and couldn't talk about or what you could and couldn't share about a patient depending on diseases that they had. And that became an issue in terms of EMS providers not knowing when they were being exposed to various things. The Ryan White Care Act actually was passed in order to create some protections for us in that regards. That if you have been exposed to certain deadly diseases, dangerous diseases, there are laws that require that you be notified and that appropriate care opportunities be provided to you if you've been exposed. And so that's an improvement, and it's a change in an ever-changing situation. They lump laws into several different types of categories. You've got legislative, which are those that are established by the government. In Oregon, that's the Oregon Revised Statutes. They can also be passed by Congress, City Council, counties that create ambulance service areas, those type of things. You've got administrative, which are the administrative rules. And those are regulations that are developed by a governmental agency based on those legislative laws. So in the Department of Human Services in Oregon, the Oregon Administrative Rules are what outlines exactly what your certification and licensure requirements are. Those rules, administrative rules, can be changed more easily than laws because it doesn't require Congress to change it. But that's where the nitty-gritty about how your license is administered, how you renew it, how much continuing education is required, all those things that really get down to the day-to-day things that affect us as EMS providers are identified in those administrative rules. Another category of law is common law or case law. And this is when a case, whether that's a civil case or a criminal case, often a civil case, goes all the way through the court process, through appeals, and becomes established that a decision has been made about how this sort of circumstance should be handled. That becomes the foundation for decisions in the future. Great example of that in EMS is Michael Montecalvo and a decision regarding Code 3 ambulance operations. If you're not familiar with this story, he was a firefighter paramedic who was responding to a call, what ended up being a minor incident. And in response to the call, or while en route, he was going Code 3, blew through a red light, struck another vehicle driven by a pregnant woman. She and her unborn baby were killed, and as a result, the court case decided that he was criminally responsible for that, and he was sentenced and sent to jail. This is the first time in the U.S. that an EMS, an emergency response person, had been criminally charged for causing harm as part of an emergency response. And this was a huge game changer in terms of how our role as emergency vehicle operators changed in this country. And since then, other cases have pointed to that case as an example that this has already been determined, this has already been decided, and this is how we're going to make a decision on whether or not someone should be charged criminally. Criminal law obviously is just that. It's those laws that our society has determined are things that can't be done, and those result in fine, prison, or both. And yes, EMS providers are subject to criminal law, especially if they overstep the bounds in a variety of areas. In a case of criminal law, the evidence must prove that the defendant is guilty. It's just a little different than tort law or civil law, which is what I'm going to talk about next here. And this is lawsuits. Anybody can sue anybody for anything in this country, and it can often be a long, drawn-out, expensive process, regardless of whether you've actually done anything wrong or not. In medicine, malpractice or things related to malpractice are a common concern and a common area that people will pursue. Usually there are monetary awards for damages, and oftentimes these things are settled. They're settled out of court. And this can be really frustrating if you're an EMS provider, and especially if you feel that you didn't do anything wrong, because it is much less expensive for an organization oftentimes to pay a settlement and make the case go away without admitting guilt, but simply give a cash payment in order to make the problem go away. It avoids publicity, it avoids some of the negativity, it shortens the timeline, and in a settlement, or excuse me, in a civil case, the burden of proof is on the defendant to prove that they didn't do what they're being accused of, and that can be a very difficult process. This is something that happens day in, day out. When I worked in Oakland, California, we would go on responses for our the Alameda County transit system, the bus system, and if a bus was involved in an accident, everybody on the bus would complain of neck pain, because at that time word had gotten out that if you went to an attorney, told him you were in an accident on a bus, they would write a letter to the transit system, and it would typically get you a check for about $2,500 to make that case go away. Not a great use of our legal system, but one of the things you have to be aware is out there. When we talk about malpractice, there's a few key terms I'll just highlight. There's a ton of legal terms out there, but here's a few that come into play in EMS or EMS cases. One is standard of care, and that's being like the Joneses. So standard of care in medicine can change over time, but it's important that we keep up on what the current standard is, because in a court they're going to say, are you doing things similar to what other EMS agencies or other EMS providers, other places in the country would do in the same circumstance? Negligence is a big legal term that basically means you didn't conform. You didn't do what you should have done. You didn't meet the standard of care. And we'll talk about how that sort of plays out, or what's required to prove negligence. And then there's contributory negligence. So it may be quite possible that there isn't just one explanation for why something bad happened. If you're in a motor vehicle accident, for instance, it may be the driver's fault. It may also be the county's fault because the road conditions or the signal light wasn't appropriate. And so attorneys will go through a process of contributory negligence where they basically are doing a lawsuit, and they're saying that, no, it's not all the fault of the paramedic, but we consider you to be 40% responsible for what happened here, and therefore you're going to be responsible for 40% of the settlement. A couple other terms to keep in mind. Abandonment. This is typically, you'll hear about this in EMT textbooks, referring to releasing a patient to someone of lower level of care. I think the reality is that it's very rarely an issue. Abandonment comes in when you don't transport the patient, you don't take them to a higher level of care, you leave them on scene in a patient refusal situation or a non-transport situation, and that's where we're at risk of being accused of abandoning that patient. Assault, I mentioned this before, assault is actually the threat of harm. So if I say, I'm going to beat you up, I just assaulted you. When I actually hit you, now I've committed battery. So in most cases, assault and battery, you hear that all the time. Someone was accused of assault and battery because they normally go together. Well, it's quite possible that we're going to be accused of assault, battery, or false imprisonment because of the things that we have to do in some difficult situations. So if we're restraining a patient, if we're laying hands on a patient, we are touching that patient against their will, and they could potentially have grounds to say that we had assaulted them, that we had committed battery, or that we've committed false imprisonment because we inappropriately held them against their wishes. This comes down to documentation, as I mentioned before. You need to have a good story, a good description, a good explanation that justifies and explains the things that you did and the reasons that you took it to the level that you did. This is a less common term you may not have heard of before. It's called the borrowed servant doctrine, and this is critical for paramedics to be aware of, because what it says is that while you're supervising a lower level EMT or EMTs or EMRs on scene, a paramedic may be liable for negligent acts that those people commit. So think about that. If you're on scene and you're the lead paramedic and an EMT off to the side that you're barely even washing does something negligent and inappropriate, you may be considered liable for that because you are the medical provider in charge at that point. So it's not simply a matter of every man for himself and I'll worry about me, but I'm not going to worry about everyone else. If you're the paramedic in charge of a scene, you are legally responsible potentially for any act that anyone on that scene commits. So it kind of lends itself to the idea of being an effective team leader and making sure you're aware of what's being done and who is doing what. So I mentioned negligence before, and negligence is a big deal, especially in terms of lawsuits and awards. And the good news for us as providers is that for someone to prove negligence is really a tough burden, legally speaking. So there has to be 4 factors in place to prove negligence. First, you have to have a duty to act. The Good Samaritan law protects off-duty personnel, and if you do something when you're not on duty, that's going to remove this completely because you're not required to act in most states if you're off duty. But if you're on duty in a professional capacity responding, then you have a duty to act. They also have to prove that you had a breach of duty. In other words, you didn't meet the standard of care. You didn't do something you should have done. You did something you shouldn't have, or you didn't do something you should have. In some way, you failed to meet the standard of care in terms of doing the appropriate things for a patient, and there have to be damages. You can't sue someone, well, as I said before, you can sue anybody for anything, but you're not going to prove negligence if nobody was harmed by it. So even if you did something grossly inappropriate, but no harm came from it, well, you dodged a bullet there, but it's not going to be negligence. But if there are damages, for instance, your patient on the scene of a motor vehicle accident is paralyzed, there's clearly damages there. But the final thing that has to be proven is what's called proximate cause, which means that the second and third one there, breach of duty and damages, have to be connected. And what I mean by that is that, for example, in the case of a spinal injury, if someone drove their car into a tree and broke their neck and is paralyzed, if you got on scene and they were paralyzed before you started doing anything, and you've documented that well, and then you didn't treat them appropriately, didn't protect their spine adequately, if you didn't protect them appropriately, that's a breach of duty. Do they have damages? Yes, they're paralyzed. But if they were paralyzed before you got there, it's going to be very difficult for a court to prove that your failure to do the right thing is what caused the damages. Running into the tree at high speed is what caused the damages. So this is another place where documentation comes in key. You have to be able to show what you find, how you find, the condition of your patient, when you find them, changes under your care, as well as doing a good job of documenting the right things. Some categories to think about where we are likely to come into issues with litigation. And these are kind of obvious perhaps, but it's just sort of a reminder of some things to think about that you'll need to chart really well, maybe even more thoroughly than you normally do, because these are things that often end up in court. Motor vehicle crashes where a public institution is potentially at fault. When a police car hits another vehicle, when a fire engine, even a public utility vehicle. If it's a public institution, there's this perception that there's some deep pockets there and there's some money that people can go after. Motor vehicle crashes involving alcohol, especially if it results in a death or injury to bystanders. So you'll see these calls, you'll be on these calls. It's obvious to everyone involved that this person was driving under the influence and caused this mayhem. Expect that those cases are going to go to court in some capacity, whether it's a civil suit, a criminal case because of the drunk driving incident. You should just expect that cases like that are going to go to court and document accordingly. Domestic assault or abuse cases, oftentimes our documentation could be a key component of whether or not charges are successful against an abuser. Any suspected breach of confidentiality. In recent years of HIPAA issues, this becomes huge, and we have to really be on guard about this issue, which I'll talk about next. And then gut feelings. If you've got a gut feeling that something just doesn't feel right, if this just seems janky and you're not sure why, but something doesn't seem right, if people seem to be asking questions like they're digging for information, if something seems like an unlikely scenario. I'll give you one example. I've been more than once on calls to a grocery store where someone is laying on the floor in the produce area with wet water on the floor, laying on the ground, claiming that their floor was wet, they fell and hit their head and are having pain as a result. That may be exactly what happened. It also may be an opportunity for a lawsuit, that someone walks in, sees a wet floor, or spills something on the floor, lays down on the floor, and claims that they've been hurt. There's some great videos out there on YouTube of people doing exactly that, positioning themselves, posing, all caught on security cameras, and then claiming that they slipped and fell. So if you're getting a feeling that someone is looking for an excuse to sue someone, make sure your documentation is really thorough so you don't become a part of the problem. Patient confidentiality is huge these days, and I will keep this really short and simple on this part, but we have to keep in mind that patients are entitled to confidentiality in terms of their medical records and their medical information. And most of you have probably heard this to the point of nausea, but it is key information and it can get us into legal issues if it's violated. So the key areas that are protected are patient information, assessment findings, and treatments rendered. Essentially, anything that you learn about or know about related to a patient's medical condition because of your role as a medical provider is confidential. And the issue then is, who can you share it with? And the people that you can share information with is a very short list. Even a patient can't get copies of their medical records without requesting it in writing. And so if it's a facility, they get patient's permission in writing. If it's your ambulance service or your fire agency, patient's going to have to sign something saying that they're requesting it in writing before a chart will be released to them. But obviously they have a right to those records. Anyone who's a part of the patient's continuation of care has a right to those records. So the receiving facility, the nurse at the hospital, the doctor at the hospital, the people that are going to be caring for this patient in the ICU, as long as it is a continuation of the care. And that applies to EMS. If a patient is leaving the hospital in your care, you have a right to have access to look at their chart, to see the information, to find out if there's relevant information there related to that. The other entity that has right to access patient information is the billing, third-party billing. So your company's billing office, the hospital's billing department, anybody who is billing insurance or Medicare or anybody else for the services has to know the details of what was cared for, what was done. They're restricted by all the same confidentiality laws that you are, but they have a right to that information. And that's it. That's the entire list. If a police officer says to you after a call, I need a copy of your chart, you cannot legally give him a copy of your chart unless he asks that with a subpoena in hand and says, I have a subpoena from a judge saying that you need to share a copy of that chart. Sharing your medical records with law enforcement or anybody else outside of those three categories cited here is going to be considered a violation of confidentiality. And this is where war stories get you in trouble. We tell stories. In EMS, we tell stories a lot, and it's a powerful part of our learning and our culture. And in an appropriate setting, in a continuing education setting, in an area where names are disidentified and you aren't going to link up the people with the problem, that may be appropriate or acceptable. But we have to be really, really careful, and we have to think about why we're telling the stories, when we're telling them, and especially who we're telling stories to. And if you're telling a story in a way that anybody not directly involved in the care of that patient can put the pieces together and connect that medical information to a specific individual, you have violated their confidentiality rights. If you do that, you can be accused of invasion of privacy. And that's a big deal. That has been an issue that's become more and more common in EMS litigation over the last few years, and it's something you need to be aware of. So we just need to be really, really careful about who we talk to and when. If we're talking too much about stuff, there's a category of a legal term called defamation, and that's when we're intentionally providing false communication that hurts a person's reputation. But even if it's accurate information and someone else can portray it as being false or intentionally targeted at someone or injuring someone, that can be a problem. They fall into a couple categories of libel and slander. Libel is when you write something down. If in your chart you say patient was drunk, that's a libelous statement because you may or may not know that. Instead, documenting as a medical provider, patient was exhibiting an altered level of consciousness and the smell of apparent ETOH on breath. Making clear objective observations is fine. Making what could be interpreted as judgmental statements is going to get you into trouble. And slander, just like libel, but those are verbal statements. So when you say the same sort of thing and anybody hears it, you could be accused of slander. So last category I'll talk about here is consent, and there's several different components to this. And basically, we lump it into informed consent, which is when you have a patient who's an adult, who's competent, who understands what's going on and agrees to treatment. And that's the majority of our patients. That ties in well to expressed consent, meaning that they're actually verbally telling you, yes, I want you to take care of me. Calling 911, unless someone else called on their behalf, perhaps, but that can be considered an expression of consent. Where it gets trickier is when we start talking about implied consent or involuntary consent, and this is when you've got law enforcement or a court or somebody forcing treatment on someone when they may not want it. When we use implied consent, if our patient is unconscious, it is very reasonable to assume that an unconscious person would want us to care for them. But there's a lot of gray area here and here, obviously, and we need to be very clear on what was going on that made us decide that this person wasn't capable of appropriately saying yes or no and therefore needed our help. And we do that all the time. We do it frequently, and we can do it frequently, and we do it in the best interest of our patient. We just need to document the circumstances very clearly because it may be portrayed differently afterwards. So comparison real quick of ethics and laws. And when we talk about ethics, we need to kind of decide, how does that fit into the legal picture? How does that compare? And as I said earlier, we have laws, we have ethics, we're held accountable to both. Laws describe what's wrong in the eyes of society. Laws change over the course of time, such as racial segregation laws, domestic violence laws, etc. There's a lot of examples out there of how our laws evolve over time. Ethics, on the other hand, is kind of a bigger picture. Take a step back and look at it, and often is a more positive spin because it really talks about and looks at what is good and right behavior. What are the things that we should or shouldn't do? And this varies from individual to individual based on their personal experience, their religious beliefs, their cultural values. A variety of things can impact what people believe is ethical and appropriate. Some common ethical situations you will get into in EMS is around patient consent, which I talked about, especially patients who are refusing. So a patient who doesn't want your care or your treatment, and even if they need it, even if it would be in their best interest, remember that patients have the right to refuse, even if it's not in their best interest. If they are conscious, alert, oriented, fully aware of the decision they're making, they can do that. Hospital destination choices, choosing where to take a patient, whether that's their preference or what's best for them, can get a little bit tricky. Advanced directives, pulse orders, things like that, where people have made decisions in a doctor's office about what they might want to have happen in some hypothetical situation in the future. Well, for EMS providers, we're not having that conversation about what they might want in the future. We're there when it's really happening, and sometimes perspectives change or family members don't agree with what the patient had decided, and various things come in that can create some very challenging ethical situations. The obligation to provide care. We have that obligation, and there are a variety of circumstances where that can get tricky. Things like parents of children. If the parents don't want us providing care, parents do not have the same rights to refuse needed care for children that they do for themselves. And patient confidentiality, which we've already talked about. So a few questions to ask yourself as you're trying to decide, are my actions right? Are they appropriate? Are they ethical? And this is really, really simple stuff. What is in the best interest of my patient? Am I doing this for my patient, or am I doing this to my patient? And really, those two questions really tie together. And am I doing this for the patient, or am I doing it for myself? In other words, is my decision really focused on what's in the best interest of the patient? And can I document that convincingly? Because that's probably going to be your best defense, is to be able to convince someone else that, yeah, we were doing what we absolutely believed was best for this patient. And if you can honestly say that and document that, you're in a very defensible position. Another question to ask yourself is, would you be comfortable explaining this action to your mother? Would you be able to explain this to someone who you may want to impress, or that you might want to have a high opinion of you and your care? Would you like to see your actions described in the newspaper or on the nightly news? And would you want a video of this call to go viral? Do you if you think about the way you manage a patient, the way you manage a call, the way you interact with a patient, is this something you would be proud of if it ended up on social media and a lot of people were talking about it? Bottom line is, your best defense is to do the right thing, even when no one else is watching, and do the right things for the right reasons. And when you're done, document it really well. Thanks for listening.